Let's try question 2 from the February 2024 California bar exam. And if the work we're doing here is of help to you, please consider supporting us by going to our Patreon page and subscribing. It's a very low fee, and what we're building there is more intense reviews of the law by editing our original lectures from some years ago, updating the ones that need to be updated. That's patreon.com/barsecrets. What do we have here? The first thing I see is that it's a very dense, very long hypothetical. And I see the first call, and that the questions continue on the next page. The first call says, what claims can Chemco Incorporated make under the United States Constitution, and how should the court rule? That is straight constitutional law. So let's see if this is all con law or if there's a crossover here. Call 2. What claims can A and L Berries make under the United States Constitution? Still con law. So far we have 2 entities. The third call, what claims can Organic Produce Incorporated make under the U.S. Constitution? When I'm reading the facts, I want a structure of the law in my mind so that I'm issue spotting really quickly and accurately on the first read through, and then I go back and check myself on the second read through. But I need to get all that done rapidly. So I need to learn as much as I can from the calls. I know this is con law, but I need more than that. They've given me 3 business entities fighting a law. So I know we're in the area of the Commerce Clause, but straight Commerce Clause, how are they going to give me 3 entities that different, that their rights are different, that the arguments I would make, the issues I would spot would be different? More likely this is Dormant Commerce Clause. And more likely those last 2 entities differ in that one is a corporation and one is a partnership. So of course I need to read the facts to see if I've accurately spotted what we need here. The more essays you issue spot before your bar exam, the more accurate you're going to be at figuring out exactly what those calls are guiding you to. I think this is federalism. Why? Because look at call 2 and call 3. Call 2 involves a company that appears not to be a corporation. Call 3 is a corporation. Privileges and immunities clause does not apply to corporations. And maybe they differ in that one is a participant in the market and one is not. I'll have to look at the facts to see. But with that in mind, let's see how accurate that is. Let's take a look at what's in the facts. State X has many small farms selling organic produce, which is grown without the use of any chemical fertilizers or pesticides. Instead of using chemical fertilizers or pesticides, these farms organically enrich their soil with animal manure products from State X's large livestock industry. Well, those are all background facts. So far, I don't have a cause of action here. Recently, State X enacted the Organic Farming Act. There we go, a state law. When they give you a state law in the hypothetical, you're probably being asked a question about federalism, about whether the state has the power to enact this law under the U.S. Constitution, or whether it places too high a burden on interstate commerce, or explicitly discriminates, or is perhaps in conflict with a federal law. Section 1 of the Organic Act bans the sale and use of chemical fertilizers and pesticides in State X, and also bans the sale of any produce grown with or treated by chemical fertilizers and pesticides. Well, that would affect interstate commerce. It would affect out-of-state companies that import chemical fertilizers and pesticides into state X, or that sell produce that's not organic in state X. Section 2 of the Organic Act requires that all publicly funded state X institutions only buy organic produce grown in state X. Two separate sections in that act, and I need to deal with them. But this is definitely federalism. Okay. In the absence of any federal law. Why are they telling me that? Well, they're telling me don't write about supremacy clause. The issue is not a conflict between federal law and state law. It's all the rest of what we need to know in the area of federalism. So before we go any further, let's take a look at what I would have in my active memory sitting in the bar exam at this point, the way we have organized the Dormant Commerce Clause and the whole area of federalism. Let's go over to proponics. Okay, we need constitutional law, so let's unfold that. And within constitutional law, the second main topic is federalism. We have a little summary statement there that tells you that it's about state power and the limits on state power because of the national government and other states. So what's inside federalism is 5 main topics. Preemption doctrine. We don't need to worry about that because they told us there's no federal law. There's the Dormant or Negative Commerce Clause. Let's take a look at that. So it's about limits on state power to regulate in the area of interstate commerce. And we have a rule and then an analysis approach. The rule is that in general, state and local laws are unconstitutional if they either discriminate against or unduly burden interstate commerce. And then there's the analysis approach. The analysis approach is to identify the state interest. It has to be within the police power. In other words, for the health and safety of the citizens, not just for economic regulation. Those are per se invalid. And I'm thinking about Section 2 of their act. It requires that all publicly funded state X institutions only buy organic produce grown in state X. I can't think of a reason why that would be there other than to protect the economic interest of the state X farms. So I think I'm going to want to argue that Section 2 of that act is per se invalid because it's an economic regulation. And then ask if there's intentional discrimination. And then we ask if there's intentional discrimination. And if the answer to that is yes, then it's a strict scrutiny analysis. I think that Section 2 of that act has intentional discrimination, which means I would need to do a strict scrutiny analysis, and I would also need to deal with the market participant doctrine, the exception if the state is involved in the market. And so far in the hypothetical, I don't know. I haven't seen that, but we still have a lot more to read in that hypothetical. But I don't think that Section 1 intentionally discriminates on its face against out-of-state participants. So then what? Go back to no intentional discrimination, and we see that we need to do a rational basis analysis and an undue burdens test. And what's that? Well, literally, rational basis, rationally related to some legitimate state interest. And the undue burdens test is that a facially neutral state law will be unconstitutional if it places an undue burden on interstate commerce. So this is a weighing test. The benefit to the state must outweigh the adverse impact on interstate commerce. But there are a lot more issues than that in the area of federalism. So let's go back and look at privileges and immunities clause. We have a rule and we have limitations on the rule. The rule, and one of the limitations on that rule involves standing. The persons protected by the rule are individual citizens, not corporations. Corporations, non-citizens, and trusts are not protected. One of those business entities was a corporation, the other was not. So I wonder if that is at play in the difference between those two organizations. Then we have an analysis approach, again, and ask whether the state or local law discriminates. If it does, is there a substantial justification for it? That's privileges and immunities clause. I suspect that's at play in the difference between Call 2 and Call 3. Then, what other issue within federalism? Well, go back to the contracts clause. We open that up and we see that states may not enact laws that retroactively impair existing contracts. And then, under our analytic approach, we see that there's a difference in the law, in the constitutional right, for private contracts as opposed to public contracts. And I don't know what we've got in the rest of this hypothetical, but it's likely that we're going to need this area of the law too. We're talking about a whole lot to analyze here. So how do you deal with that? Well, you have to know that the Dormant Commerce Clause is going to take up most of your analysis, and that you're going to have to hit the rest of it, privileges and immunities and the Contracts Clause, much more lightly. At least they gave us that we don't need to worry about preemption doctrine. Back to the hypothetical, and let's see what we've got. We have, in the absence of any federal law, the state X legislature passed the act after concluding that the use of chemical fertilizers and pesticides contributed to measurable environmental harm. It further found an increased threat in the health of farmers using chemical fertilizers and pesticides, as well as the health of consumers of the farmers' produce. That is the state interest, and it's squarely within the police power, health and safety. But it goes on to say the state X legislature also declared that it wanted to preserve the existence of small farms and to protect those farmers' way of life. Now, that gives you a way to argue that this was an economic regulation, that this is protectionism. It's to protect the economic interest of those farmers. So I'm going to want to use that. All right, go on. State X has no significant chemical fertilizer or pesticide industry, so they're not a participant in that market. Chemco Incorporated in nearby state X is a chemical fertilizer and pesticide manufacturer that has always had a significant portion of its revenue come from sales in state X. Those facts go toward Dormant Commerce Clause. They have given you the burden, the undue burden that's going to be placed on that chemical fertilizer company. So there's Chemco, that's call 1. And given what I know about how Dormant Commerce Clause fact patterns work, I would expect that to be the largest call in my answer. I'm going to have to go through Dormant Commerce Clause, Privileges and Immunities, and Contracts Clause. Next paragraph tells us that A&L Berries is a partnership that grows and sells organic strawberries in state Y. A&L Berries sells some of their strawberries directly to consumers in state X. However, most of their sales are to Organic Produce Incorporated, a state Y wholesaler. Both A&L Berries and Organic Produce Incorporated have publicly funded state X customers who now refuse to do business with them because of the Organic Act. Okay, so that paragraph goes to both calls 2 and call 3. There's a lot of information in that paragraph. First of all, the difference between A and L and Organic Produce Inc. is that A&L is a partnership, Organic Produce Inc. is a corporation. It's incorporated. So Organic Produce Incorporated will not be able to use Privileges and Immunities Clause. But A&L Berries, as a partnership, probably will. So, call 1 is the huge Dormant Commerce Clause call. I need to do not only Dormant Commerce Clause analysis, but also, of course, Privileges and Immunities and the Contracts Clause for call 1. They gave me the state's interest, which was squarely within the police power, health and safety of the citizens. There was quite a dense paragraph about that. But Section 2 of the Act is more about economic protectionism. And as I said, I would argue that that's per se invalid. As to the question about whether there's intentional discrimination, Section 1, I don't see it. Section 2, I do. All publicly funded state and X institutions only buy organic produce grown in state X. That intentionally discriminates. So this is quite a complex Dormant Commerce Clause analysis. We also know that for the section that does not, Section 1, the section that does not intentionally discriminate on its face, the burden on interstate commerce is quite high, because they told us that that company does most of its business in state X. Chemco is a corporation, so it can't use Privileges and Immunities Clause, but it certainly can use the Contracts Clause. Call 2 is about A&L Berries, and we're going to need to do the Dormant Commerce Clause. You can make that a much briefer analysis in that you refer back to what you did in call 1. The twist there is the burden on interstate commerce as far as they're concerned, because they sell only a little bit directly in state X, but they sell a whole lot to the entity in call 3, Organic Produce Incorporated. So indirectly they're selling a lot in state X. Then under Privileges and Immunities Clause, they can use that clause. Distinguish them from the entity in call 3, Organic Produce Incorporated. They cannot use the Privileges and Immunities Clause. So look, this is a huge amount to analyze in the roughly 45 minutes you would have left after you spend 15 minutes in analyzing the issue spotting, the hypothetical. The way you survive that is by doing a really fine job on Dormant Commerce Clause in call 1. And that's your strongest cause of action, and so that's what you want to start with. Then also explain Privileges and Immunities and Contracts Clause well in call 1. In calls 2 and 3, you refer back to the analysis you did in call 1, and you heavily distinguish the two entities in call 2 and call 3, because the essential difference there is that Privileges and Immunities Clause difference. It's a tough analysis to finish in the amount of time you have, but look at the huge advantage you have if you have that organized, clear, concise structure of the law already in your mind. Constitutional law is a huge subject, but this is a mountain you can climb. by creating for yourself a concise, organized summary of the law in each of the topics in constitutional law that's so frequently tested on the California bar.